Well, good evening, everybody. Nice to see you all. Liverymen, ladies and gentlemen, welcome indeed to Stationers' Hall. Not only would I like to welcome you all, but particularly I'd like to recognise Sir Robin Jacob, the Sir Hugh Laddie, there you go, Chair of Intellectual Property at University College London, who, after reading Natural Sciences at Cambridge, went on to read law in London and had an outstanding career, culminating in the appointment as a Queen's Counsel and later as Lord Justice Appeal. Jill Jones, who I know is here, the chair of our industry committee here at Stationers' Hall, and I were both undergraduates at University College London, at different times, I have to say. Sadly, neither of us sat on the professor's feet in the UCL law faculty, despite the attraction of several jolly good parties that the law students used to organise. But that's another story. I won't come to that later. But nor did we reach such dizzy academic heights as Sir Robin. In July of last year, I received a message on LinkedIn from the professor, alerting me to the fact that the 250th anniversary of the case of Donaldson versus Beckett was just around the corner, April the 10th to be precise, this year, and warranted recognition and reflection. Given the role of the Stationers' Company that it played in the development of copyright, not only in the UK but also around the world, I gladly supported the idea that the Stationers' Company and UCL should co-host an event to recognise the importance of this case and the implications of its judgment. Now, I do recognise many familiar faces in the room today, but also know that there are many folks who don't necessarily know much about the Stationers' Company. So please forgive me if I spend a couple of minutes just to tell you who we are, particularly as there is this link with copyright. The Guild of Stationers was set up in 1403 in the reign of Henry IV, so we are very medieval in our roots. We originally looked after the interests of scriveners and illuminators of parchments, but later printers and publishers in the City of London. In 1557, Queen Mary Tudor gave us a royal charter which required the Stationers' Company to police what was being printed and published not only in the City of London, but throughout the kingdom. Any books or manuscripts which were deemed seditious by the Crown or heretical by the Church were seized and destroyed by the Stationers and burned in our garden back there. That's why the tree grows so well, by the way, if you haven't. That's another story. I'm not sure that's true, but never mind. The Stationers' Company required all books to be registered here at Stationers' Hall and awarded the right to copy before they could be printed and published. Thus, the Stationers played an important role in the culture of England as it evolved through an intensely turbulent decade of the Protestant Reformation and towards the Civil War in England. So, the form of protection for printers and publishers lasted from 1559 through to its lapse in 1695, when the government of the day felt it was more important to foster the encouragement of learning and the encouragement of learned writers to compose and write books. Legislation followed in the form of the celebrated Statute of Anne, or the Copyright Act of 1710, and making sure that the Stationers' copyright was a protection granted to printers of a book. Copyright, introduced by the Statute of Anne, was a right granted to the author or authors of a book based on statutory law, which led to the end, sadly, of one stream of lucrative income for the Stationers' Company. The case of Donaldson versus Beckett in 1774 was a major test of the implications of the Statute of Anne and the future of copyright. So, today, we are one of the 111 livery companies within the City of London, and we serve the entire communications and content industries, from paper and print through to authorship, publishing, journalism, broadcasting, to digital media. We have 1,000 members, which gives us a very diverse view of the whole communications supply chain. Our company's principal purpose nowadays is to provide an independent forum where its members can advance the interests in strategic, educational, training, and charitable terms of the industries associated with the company. Our home is this hall. It was opened in 1673 after the Great Fire of London consumed its previous version on the same site. This hall, now 350 years old, is the second oldest livery hall in the City of London. Fortunately, our copyright archives were saved from the flames and represent a valuable record of the world of printing and publishing from the 1550s to 1842. So our company is open to new members who have a background in the communications and content industries, and we welcome inquiries by those interested in applying to become a member, either through our website or personal contact with members of our company. That's the publicity for today. I am now very happy to hand over to Sir Robin to lead us in a special evening of perpetual debate concerning the concept of copyright. Where does copyright go next? So Robin, over to you.
Well, thank you very much, Master. I can't remember who told me it was the 250th anniversary, but it came up, and almost at the same moment, I saw something on LinkedIn, and I spoke to Carol Tullow, and here we are. I'm slightly puzzled. The Masters referred to the monopoly which the stationers had. And Donaldson and Beckett was very much a case undermining that monopoly, because it's decided there was no copyright other than that under the Statute of Anne. And well, why are they doing it then? And the answer is because they're really good sports. No more, no less. Well, I had to get a panel together, and my first choice was Hector MacQueen, because he is representing the Scottish booksellers, the enemy.
The winners.
The pirates from north of the border, because they had no statute of Anne there. Scotland was a different country. Whether it still is remains for debate, probably forever and a day. But I met Hector years ago and discovered there was this brilliant bloke in Edinburgh who was really sound on IP, but particularly copyright. So he was an obvious first choice. Professor at Edinburgh University. He got me to go teach there once. Very satisfactory day it was. And he said he would do this immediately. Obviously, he's not going to stay in England. He's going to be on the train tonight. For many years, he was the Scottish Law Commissioner, doing rational and sensible things to our Scotland. Probably a better job than was being done by some of our Law Commission reports. But there we are. The next speaker is Jaani Riordan. He's from my chambers. So he's got to be getting good, hasn't he? And he became a station when he got here because he'd come from Australia and wanted to get a touch of respectability.
Wow.
It hasn't really worked, but nonetheless, you don't have to be respectful in my chambers, you just have to be very good. And our last speaker knows everything about what's going on now. She knows everything there is about the world of modern copyright. She says she doesn't. She says she'd be worried, but not really. So I'm going to say any more at all, because it's not my job to tell the story of Donaldson and Beckett. It is, first of all, Hector's job.
Okay.
Thank you very much, Robin, for the introduction, after which disappointment is the inevitable result for the audience. But it is a pleasure to be here, and although it's been a little while since I did any work on the history of copyright, this place is right at the heart of it, and I've always enjoyed visiting it and wandering around the area, which was the publisher heartland in the 18th century, not only for England, but also in many ways for Scotland as well. Just a couple of introductory observations. My title, you may notice, talks about the war of the booksellers rather than the battle of the booksellers. Donaldson against Beckett was certainly a battle, but it hadn't been the only battle. It was a war that had gone on for at least 40 years. So that's what I'm going to attempt to justify in what I've got to say. The other thing I want to say is that the Scots were all over this particular story, on both sides. This is perhaps a good Scottish trait. One of us will end up as the winner, that's certainly a national characteristic. I want to talk first, if I can just click my slides. The first thing to talk about is the context. The Master's opening remarks have spared me the necessity of explaining that from 1695 until the Statute of Anne, there was literally no regulation of publishing and printing in England. So certainly one of the things that the Statute of Anne was attempting to do is to put a new regime in place, but a regime is perhaps worth highlighting that no longer focused primarily on censorship and control, but rather on getting information about what was going on and providing encouragement to authors and publishers to reveal their identities in order to claim the rights that the statute conferred upon them. But the other bit of context, which is important, I think, is the Union of 1707 between England and Scotland. Now, while the Union preserved the different legal system and the different laws of the two countries for various reasons, some exceptions to that were made, and one of the exceptions, I think, enabled the Statute of Anne to be made, because it does apply to Scotland. With all due respect to the chairman, it does apply. I'll just come back to the context. It does apply in Scotland. If you read it through, you'll see there's lots of provision about Scotland within it, and the rights that the statute conferred were as available to Scottish authors and publishers as to their English counterpart. And the reason for having the Statute of Anne, I think above all, was in fact that another effect of the Union had been the abolition of the Scottish Privy Council, and the Scottish Privy Council was the body that was responsible for licensing, publishing activity in Scotland up until its abolition. So in both countries there was a gap. That's the crucial point. And it was a gap which needed to be filled in the world as it was developing in the early 18th century. Next on content, apart from the fact that it does apply to Scotland, and I think this is obviously sometimes overlooked, the basic content of the rights is already, I think, before you. Basically, authors and publishers were given the right to apply for copyright via registration in Stationers' Hall, and authors were given the right to renew, and in each period that was involved, it was a period of 14 years. And in some ways, if it's helpful to some, at least in the audience, it's a bit like the patent system or the trademark system, perhaps more pertinently, where there is this process of renewal of the right if you want to keep it. Now, only the author was entitled to the second period. The publisher wasn't entitled, but the publishers soon sorted that out by virtue of getting the author to assign the author's right to the second lot of 14 years in their direction. So, in effect, what you were getting was a copyright which would last for 28 years from the date of registration. Now, the critical first steps that lead up to Donaldson against Beckett were being taken certainly by the 1730s. And it was via that curious thing from the Scottish perspective, equity, the courts of equity, separated from the courts of law. And the long quotation on the slide is, I'm afraid, from my own writings, but I haven't given myself the credit on the slide itself. But the basic point was that the courts of equity, at the behest of the publishing interest, decided that if the parties waived their rights under the Statute of Anne, they could make a claim in equity for the remedies which were particularly useful, namely the injunction, the prohibition of publishing against pirates, as the publishers saw them, and also an account of profits. So if the pirate made a profit from its activity, that could be claimed by the copyright holder. And these remedies were far preferable to the ones that the statute itself provided. And the English Court of Chancery doesn't seem to have put up any obstacle to this development of equity. And I think it's probably fair to say that it's because the court perceived that the publishers had a fair claim to do rather better than they seemed to do under the statute. Now, in Scotland, as one of my friends in the audience well knows, we mix law and equity. We don't have separate jurisdictions, and that was as true in the 18th century as it is today in the 21st. And you know, from an English perspective, an English equity perspective at any rate, the idea that you can mix law and equity is as puzzling to them as is the idea that equity can be separated from law in the eyes of the Scots. Now, attempts were made in the course of the 1740s and early 1750s to persuade the Court of Session, the Court of Mixed Law and Equity, to use its equitable powers in order to give publishers the same remedies as they had in England. And in the case which is mentioned on the slide, that was refused. And what's interesting about it is that counsel for the defenders in this case was a chap called Henry Hume, who later became famous as Lord Kames, a judge in the Court of Session. And what Lord Kames did in 1760 was to publish a book which was directed at a wider audience than just Scotland, called The Principles of Equity. And I think the signs are that he first began to think about these principles of equity at the time that he was dealing with the case of Midwinter against Hamilton. And his argument was, and I must say it's an argument that I find attractive, that even if you have a separate system of equity, as here in England, equity cannot cure a statute. A statute is the law, and it can't be supplemented or added to by ideas of equity. Parliament has decided this is the law. It's not for the courts, even courts of equity, to intervene and try to supplement what's there. And a particularly important idea for Kames, as he expressed it in his book, which was first published in 1760, was that equity could be used to prevent loss, but it couldn't be used to make somebody richer at the expense of another, i.e. the booksellers in our particular example. So there was a fundamental split between England and Scotland at this particular point. And it was based largely on the different views taken of the concept of equity, how equity relates to law. Now, what came next in the saga, or in the war, perhaps I should keep repeating, was the crossover in England from equity into the common law, with particular regard to the problem of the post-expiry right. And the great case of Miller against Taylor in 1768, a case at common law, not at equity, held that there was a continuing right for publishers and perhaps also authors after the expiry of that statutory period of 28 years. And it's worth noting that a leading judge in this case, in a 3-1 majority decision, leading judge was Lord Mansfield, another Scot. And that the bookseller, the London bookseller who was raising the action, was also a Scot, who for some reason had thought they could do better in London than they might be able to do in Edinburgh. Mr. Taylor was a bookseller in Berwick, which, as you know, I'm sure, is not in Scotland anymore, not since 1482. But I actually think there's an interesting question to be discussed about what the legal status of Berwick was right up until the 19th century. It's famously said that Berwick is still at war with Russia because the declaration of war said England, Scotland, and Berwick upon Tweed, and the declaration of peace failed to include Berwick upon Tweed. And this is the sort of thing that led to stories about Russian soldiers landing with snow on their boots during, I think, the First World War rather than the Second World War. Now, that's all very interesting, but the key point really is the crossover from equity into common law in order to provide a clear right. In supplement of the statute certainly didn't provide for it after the expiry of the statutory period. Now, my next Scot is Alexander Donaldson, and in a way I'm surprised that the walls of the hall don't crumble at the very mention of this man's name. Alexander Donaldson, who would in due course become the appellant in Donaldson against Beckett, was to begin with a publisher in Edinburgh who strove to take advantage of the position declared in Scots law in midwinter against Hamilton, that the remedies of interdict, as we call injunction in Scotland and so on, did not apply. The statute was the sole guide as to remedies. And therefore, in Donaldson's view and the views of the lawyers with whom he was careful to keep friendly, the statute was the end, if you like, of copyright. You couldn't go beyond the statute to add in post-expiry rights. Now, Donaldson's got a fascinating career because what you find is that he decides to move to London. He takes the fight to the enemy, and especially after Miller against Taylor had seemed to knock his view of the matter so very firmly on the head. And he was based just outside where we are now in St. Paul's churchyard, so he was right in the face of the stationers, I'm afraid. A little later on, he moved to the Strand, and I'll explain, perhaps, if I've got time, what his reasons for moving to the Strand may have been. But in St. Paul's churchyard, he was in partnership with his brother. And he ran a pamphlet war and all sorts of things that you did in the 18th century. So, question arose in Scotland first, I think it's fair to say, or perhaps, no, Miller against Taylor is the first. Hinton against Donaldson is a Scottish response to Miller against Taylor. Donaldson, you'll have worked out, is our friend Alexander, of whom we've just briefly discussed. Hinton was a London bookseller. And what Donaldson was doing was defying Miller against Taylor, because Miller against Taylor had been about a book by a Scot, James Thomson, called The Seasons, and what the effect of Miller against Taylor was to say, copyright persists in Miller against Taylor, even though the statutory period has expired. Donaldson in Edinburgh just kept on churning out his unlicensed versions of that great work. And Donaldson received complete vindication from the Court of Session. By 10-1, 11 judges sat on the case. The idea that there was any post-expiry right was simply rejected. And that was in 1773, just a year before Donaldson against Beckett. And what's quite clear is that Donaldson was using this Scottish case strategically to throw a brand, if you like, a flaming brand in the direction of Miller against Taylor and the court that was going to consider Donaldson against Beckett. Whoops, jumped a line. Donaldson against Beckett, 1774, was a case where the Court of Chancery, we're back in the world of equity, granted an injunction to prevent reprinting of the out of statutory copyright, the seasons, and that injunction having been granted, Donaldson appealed to the House of Lords. He also took the precaution, it's worth noting, of getting out of his lucrative partnership in St. Paul's Churchyard and buying the property in the Strand from which he henceforth did business. And I think it was really just to save his assets in case he lost the case in the House of Lords. And the House of Lords, obviously seeing controversial points, says, well, let's take the opinion of the judges. And a dozen judges were hailed to the House of Lords in order to express a view on this question which had been raised. Is there any post-expiry right in literary material? Now, the judiciary, interestingly, was entirely English. It hadn't really occurred to me to think about this until I started my line of the Scots are all over this, but they're certainly not all over the judicial opinions. And when you read up about the judicial opinions, you find that there's actually a huge division of academic opinion on how many judges voted for what. And I'm not going to try and resolve that particular discussion. Because after all, it doesn't really matter that much. What the judges were being asked to do was to give their opinion and advise the House of Lords before it conducted a debate on how to deal with the appeal. And after the judges had given their opinions at length, and one should perhaps note that Lord Mansfield was one of the invited judges, but did not give an opinion for reasons which remain doubtful and uncertain, the House of Lords then had a motion put to it that the Court of Chancery decree in this case should be reversed. 5 lords, and they're not law lords, it's important to stress, they're just members of the House of Lords, spoke in the debate. Four were for reversing the decision in Chancery. Only one was in favour. And thus Donaldson against Beckett came to be decided as it was. There was no post-expiry copyright in the law of England, just as had been held was the case in the law of Scotland. And I think there's no doubt that the Scottish decision had its effect. Donaldson had managed to get it printed, so it was there in front of the House, and the judges in the House could see the reasoning and also the law lords. Now, the effects of the decision, if I can move on, perhaps what I've highlighted here expresses it best from the point of view of the discussion I think we hope to have later on. It's Lord Camden. I can hardly read, the print has come out so small in my printed version, but basically what Camden was saying was, we can't give the publishers a right that lasts forever, because that was effectively what was being claimed. It would close out, oh no, we're going too far. It would close out knowledge and learning. Okay? So that's really the sort of policy, as opposed to the legal argument that commended itself to the 4 law lords who formed the majority in this case. And the thing that I think this really confirms is that Donaldson can be seen as the destroyer of a world that had existed up to that point perfectly satisfactorily from certain points of view in England. And I was reminded, preparing for this, of the Austrian economist's idea of innovation as being about creative destruction, or if you prefer, destructive creation. But I think creative destruction is what Schumpeter actually said. And I think Donaldson is an excellent example of that. He transformed the world of publishing as it had been previously understood in England. And the platform for doing so was his position in Edinburgh. And it's certainly very interesting to note in my final slide a quotation from contemporary record of the reaction to the decision in Edinburgh. A mob stormed through the streets triumphant, letting off fireworks and so on. So it clearly was seen as a Scotland-England question. And I was reminded of that too, because I attended the Calcutta Cup match on Saturday. Yes, that was a very interesting and enjoyable occasion. So I can understand the reaction in Edinburgh. Donaldson had built up a very large network of friends and supporters, and he got the celebration that he wanted. There's a bibliography on the slides which you can consult or not as you see fit, and that should help fill in the many gaps in what I've said. Robin.
It really was a huge event in London. The case was heard in Westminster Hall. Same place Charles I was tried. 700 years old now, maybe it's 800. And society went to hear it. Can't imagine them doing anything like that now, can you? Jaani's going to pick it up. What's happened to copyright then? Then copyright was 28 years, full stop. What happened then?
Thank you, Sir Robin. So I'll focus on the legacy of Donaldson and Beckett, and I'll make two overall points. Firstly, that the legacy of the decision is to abrogate a perpetual common law copyright, but that has been eroded by a succession of statutory term extensions and international harmonization, all aimed at conferring extensive multi-generational rights. The second point I'll make is that a panoply of other rights, some common law, some statutory, has emerged, which also confer quasi-perpetual control over the same subject matter, even after expiry of copyright. I'll pick up the story in 1775, the year after the decision was handed down. But before I do that, let's go to the 1st of January 2024. What do all of these works have in common? Yes. The answer, as many of you will have guessed, is that UK copyright expired on the 1st of January, and these works entered the public domain. In the case of a few of them, US copyright also expired, and that provided the immediate trigger for the expiry of UK copyright. The reasons, however, are more complicated. For most works, that is because their authors died in 1953. Prokofiev, D.H. Lawrence, Dylan Thomas being good examples. But for the works with an asterisk, they were authored abroad by a foreign author, and the term of copyright therefore ended under the applicable foreign law. UK law, under the Copyright Designs and Patents Act 1988, follows the rule of the shorter term, and that's why Steamboat Willie, which was published first in 1928, expired under US law on the 31st of December 2023, and therefore in the UK. There is a reason that all of these photographs of the authors are in black and white. They were all born in the late 19th or very early 20th century. So, as Sir Robin asked, how has a term of copyright that began as 28 years ended up protecting works published over a century after the works were published? I'll structure my short remarks in 4 parts. Firstly, a couple of minutes to discuss the immediate aftermath of the decision and how it was greeted by different stakeholders. Secondly, the history of domestic term extension in English law, or UK law, I should say. And thirdly, and relatedly, the impact of minimum standards of protection under the international copyright conventions. Finally, I'll address some of the quasi-perpetual rights that I mentioned and their impact on expired copyrights. So, the aftermath of the decision. In the immediate aftermath, as Professor MacQueen has mentioned, there was some confusion about how to interpret the decision and what had actually been decided. At the risk of simplifying quite a lot of academic scholarship, there were two main views as to what might have been decided by this casting of lots in the opinions expressed by their lordships. The first was that the House rejected the existence of a common law right per se, and that's the absolutist statutory view. You have only the copyright given to you by statute and none other. The second view, which was Blackstone's view, was that the decision was narrower and was simply a ruling that once works were published, they were from that point governed by the terms of the Statute of Anne, and therefore any prior rights which might otherwise have existed were abrogated by the Act. Did the decision actually decide either of those points at all? There is, of course, another argument that if one looks at the outcome, it didn't decide either of those questions as a matter of ratio decidendi. Like my predecessor, I'm not going to attempt to resolve those two conflicting points of view. But what I will say is that the conflict between what I would call the perpetualists and the statutists can be viewed as an emanation of the conflict between natural law and legal positivism. Do authors have innate rights for all time by virtue of creating a work, which are then taken away from them by statute or by regulation? Or are they granted rights positively by a legal instrument deriving its authority from an act of Parliament? There's also a constitutional dimension to this question in that, as the learned master has mentioned, printing was licensed by the Crown under its prerogative, but the Statute of Anne brought copyright within parliamentary control. And so at play is a fascinating intersection of law, politics, and of course the commercial interests of the booksellers. Certainly, however, the universities were under no illusions as to the threat that they faced from the decision. In 1775, being much alarmed by the determination, they successfully lobbied Parliament for an act to grant a perpetual statutory right in their own deposit libraries. Thus, the Copyright Act 1775 provided that the universities of Oxford and Cambridge, the Scottish universities, and the colleges of Eton, Westminster, and Winchester would hold in perpetuity their copyright in books given or bequeathed to them. As I'll come on to explain, that perpetual copyright continues to subsist today, but not forever. It's a rather odd piece of drafting, actually. Does an ordinary copyright given to an author become perpetual if it is devised by a will in favour of the university? Is the exercise of the right constricted by the university purposively to use for educational purposes? As far as I'm aware, these questions have never been addressed. The marketplace also arrived at its own view of the decision in Donaldson and Beckett. By one report, the number of London booksellers and publishers blossomed from 111 registered companies in 1772 to 308 in 1802. So suddenly there was an influx of cheap editions of Shakespeare, Milton, and Chaucer, which one could buy on Ludgate Hill, and possibly also on the Strand. It's unclear to what extent growth of this kind in the book trade was due to the abolition of common law copyright, but it's certainly difficult to imagine such a rapid profusion of publishers and their works if the right to print a work were held exclusively by a single seller. Doubtless it was a good time to be a reader of books, but what about a publisher? The view of publishers was mixed. Professor John Draper has argued that prior to Donaldson and Beckett, very few books were actually deposited under the Statute of Anne. The Stationers' Company members instead preferred to boycott independent publishers and relied on their ancient perpetual rights and their commercial practices. And so Professor Draper has argued that the Statute of Anne, prior to Donaldson and Beckett, fell into almost complete desuetude. It was only the decision in Donaldson that gave the Statute of Anne renewed purpose. Ironically, it also marked the beginning of the end of the stationers' good fortunes, though not immediately. And a good example of that is that in 1775, the company Blandon printed Paradise Lost in London, something unthinkable a year earlier because of the reliance on his common law copyright of Messrs. Thomson. So now anyone could publish an edition of Milton without risk. Contemporaneous accounts suggest that authors saw this as a very bad thing. They felt that they had lost a perpetual copyright and gained a very short one, and only then if they took steps to register it formally with this august company. Walpole complained, "I've lost all my right and title in my own things, merely because my bookseller neglected to enter them in Stationers' Hall." Meanwhile, on the continent, we started to see more universal acceptance of the idea that literary and artistic works should not be monopolized in perpetuity. One can see the seeds being sown for a more international regime, which is based on a term of years post-mortem auctoris. Thus, Napoleon complained in 1805 that the progress of the Enlightenment would be stopped if one could not circulate works, notes, and commentaries with freedom of printing. And he decreed that authors should have, in France, the right to control printing of their works during their lifetime and their heirs for a period of 10 years following death. He added, almost as an aside, perhaps a longer term of 20 years after death could be justified to protect the widow. In the UK, by the 1850s, there had been several further decisions applying or citing Donaldson and Beckett, and I'm going to give one example in the time I have. This is the decision in Jeffreys and Bussey, which is another case before the House of Lords, and this concerned the copyright in the score of an opera semiseria called La Sonnambula, the Sleepwalker, composed by Vincenzo Bellini in Milan and first performed in Milan in 1831. The case reached the House of Lords in 1854. Publisher Jeffreys sought a declaration that it owned the copyright in the musical composition, as it had first been printed and published in England fewer than 28 years ago, so it was within the statute of Anne term for subsistence. Bussey, a name well known to many publishers today, had printed unlicensed piratical copies of the score in London. Jeffreys claimed title by way of a Signore Ricordi, to whom Bellini had assigned his UK copyright. Bussey argued that no copyright subsisted in England, and the House of Lords agreed. The Statute of Anne did not vest any copyright in works created by a foreigner. What was more interesting about the decision is that their lordships then went on to consider whether there might be a common law right to fall back on, because if there was such a right, then Jeffreys could rely on it in that sense. The narrow view of the decision is that common law copyright also didn't extend to foreigners by way of qualification. But if one looks at the obiter remarks, one sees widespread acceptance of the proposition for which Donaldson and Beckett stood as authority. So Lord Brougham, for example, said that the House in Donaldson and Beckett was divided on the question of the common law right, and although the first instance decision was reversed, upon the general question of literary property at common law, no judgment whatever was pronounced. Certainly, as I've said, it's difficult to discern a clear ratio on the basis of the reports of the decision. And so once again, the House of Lords considered the arguments for and against the existence of a perpetual right. But by this point, throughout the continent and in England, the tide had shifted against the idea of an indefinite right. Now, it's clear from all of this that debates about literary property are fertile ground for policy questions about whether property rights in intangibles should be recognized and how the balance should be struck between authors and users of copyright works. And there are obvious parallels with modern debates about new forms of digital property and the mass use of copyright works in machine learning models. So copyright is now undeniably a creature of statute. The conclusion of Lord Pollock is that it is an altogether artificial right, a creature of the municipal law of each country to be enjoyed for such time and under such regulations as the law may lay down. And so in answering this question, their lordships were unanimous in concluding that there was no common law copyright under the Lex Loci Protectionis law of England. So let's now look at subsequent domestic copyright term extension. It's impossible to do justice to 250 years of copyright history in just under 10 minutes, by my count. But a one-sentence summary might be this. While copyright is now a creature of statute, the term and the bundle of rights conferred by statute has tended towards the commercial interests of prominent authors and publishers who have successfully lobbied legislators. Copyright terms have gone in only one direction, and this has led to perpetual term inflation, if not perpetual copyright itself. In this august hall, of course, one must begin with the Royal Charter incorporating this company. And I thank the learned master for his background to the events leading to the Statute of Anne. Funnily enough, the bill was submitted to the House of Commons on the 12th of December 1709 by who else? Stationers, who complained that diverse persons have of late invaded the properties of others by reprinting several books without their consent, and to the great injury of the proprietors and their utter ruin, and the discouragement of writers in every useful part of learning. It's perhaps then somewhat ironic that the result of their lobbying was a statute which, by the result, abrogated any common law right and replaced it with a fixed term, short-term right acquired by registration. But why 14 years, renewable to 28? Professor Rose suggests that the initial term may have been based on the Statute of Monopolies 1624, which prohibited, as patent lawyers will know, any monopoly of more than 14 years. Previously, terms of 10, 50, and even 70 years had been proposed by pamphleteers for the Printing Bill 1695. John Locke, for example, had proposed in a pamphlet 50, alternatively 70 years for copyright protection. A more cynical view of this is given by Dr. Feather in his book, Piracy, Publishing and Politics. The stationers who lobbied for the Statute of Anne were simply seeking a statutory footing to continue their existing commercial practices, I should say our existing commercial practices, which had been largely in place since the mid-16th century, but which were facing usurpers since Charles I's licensing bill expired in 1694, and we had no effective legal basis for the print monopoly. So the new statutory copyright started with books, and as many of you will know, it later expanded to engravings, plays, and other literary and artistic works over the course of the 18th and 19th centuries. The first copyright term extension bill I've been able to locate was from 1814, which extended the term to 28 years from publication automatically, so irrespective of whether there was a renewal after 14 years, or life if the author lives longer than 28 years after publication. The next extension came in 1842, which was the first example in the UK of the post-mortem auctoris principle, which was 42 years from publication, or, if longer, life plus 7 years. Now, this came 28 years after the 1814 Act, and although I have not found any evidence to confirm this, it seems a reasonable inference that those copyright owners whose terms were just beginning to expire under the 1814 Act might have been seeking a longer term, and Parliament evidently acquiesced to this. 1886 is our next stop on our whistle-stop tour of copyright, which was, of course, the watershed moment for international copyright lawyers. The Berne Convention was done at Berne, which laid down for the first time minimum standards of protection of copyright for members of the Berne Union, principles of reciprocity and national treatment, and importantly, by the Berlin Act revisions in 1908, a minimum term of life plus 50 years. And that was confirmed and extended to further categories of works in Brussels in 1948. We'll see what the rationale for that was in one moment. And in 1911, the English and imperial copyright legislation took effect in England and throughout the British Empire, which adopted the Berne Convention requirements, including, I'm afraid, the end of the stationers' company registration requirement. The next major event was the Term Directive in the EU, life plus 70, and most recently a 70-year term extension for sound recordings. But I don't have time to go into those in detail. So what was the rationale in the Berne Convention for life plus 50? 2 reasons were said to justify it. Firstly, fairness to the author and his or her heirs, so as to confer roughly 3 generations of protection. And second, the lack of perceived impact on copyright users due to the preponderance of blanket license agreements, for example, by broadcasters and venues, and the lack of any license fee reduction after expiry of individual works within a portfolio license. More recently, in the context of sound recording term extensions, a 3rd reason has been added, namely the longer life expectancy of authors and their heirs today. But why 3 generations? It does have the appearance of arbitrariness. Napoleon was content to look after the widow for 10 or perhaps 20 years. So what has changed? More demanding grandchildren, perhaps. I'll just fast forward a little bit to the current position in the UK, which is life plus 70 years for literary, dramatic, musical, and artistic works. Section 12, subsection 6 of the Act, which has been enforced since the 1st of August 1989, deals with the question of foreign works published by foreign authors, where, as I mentioned earlier, the principle of the shorter term of protection applies. And that's why Steamboat Willie is now expired in the UK, even though Walt Disney only died in 1966, or 62 years ago. I mentioned Section 12, subsection 7, which is a special case for computer-generated works, 50 years after being made. But one wonders whether OpenAI and Meta will be the next stationers to lobby for term extension in 45 years' time, or whether such is the constant progress of their technology, the protection of the old generation is not all that commercially significant. What about the perpetual copyrights of the universities that I mentioned earlier? Well, they were finally prospectively repealed by Schedule 1, Paragraph 13 of the 1988 Act. However, that provision will only take effect on the 1st of January 2039. Until then, those university copyrights from 1775 continue to subsist, and in principle are capable of being enforced, although I'm not aware of them ever having done so. So some quasi-perpetual copyright subsists today. In the time available, I don't have time to go through all of the international instruments, but I will just highlight the TRIPS agreement, by which all WTO members are now obliged to confer a minimum term of life plus 50 years, or 50 years from the making of the work if it's unpublished. And so we see international harmonization in relation to both published and unpublished works. As I mentioned, there have been a range of other term extensions throughout the 20th century, but I won't go into the detail of those. So, what perpetual rights remain? I've identified 5 potential categories. The first is Peter Pan, a category unto itself. There is, believe it or not, a specific provision in the CDPA which grants what is in substance a perpetual copyright to the Great Ormond Street Hospital for Children. Appropriately, it is a copyright that remains forever young. The second category is the King James Bible. Forgive the slightly academic digression here. As many of you will know, it was first published in 1611, 99 years before the Statute of Anne. James I exercised a royal prerogative to grant a privilege by way of letters patent to the King's printer and to the universities. The 1775 Copyright Act, as I mentioned, conferred parallel statutory rights upon the universities to hold perpetual copyright in those deposited works. So the consequence is that there are 2 parallel sources of right in the King James Bible, the 1775 Act and the Crown Prerogative. Now, the CDPA repeals, as I mentioned, the 1775 Act rights, but it does not affect rights granted by the Crown Prerogative per section 171(1)(b). So, at least so far as I've been able to determine, it looks like perpetual copyright under Crown Prerogative will continue even after 2039. I say that subject, of course, to the Crown copyright regime, but even that doesn't appear to repeal previously granted exercises of prerogative. There are also some other newer rights which have come about since 1774, one of which is another right in equity, an action for breach of confidence. If a work is never published, but it's leaked or otherwise dealt in without the authorization of the author, there may be an action that lies in breach of confidence. And that may be so even if the copyright had expired and the materials were never published. There is also sui generis database right, which it gives effect to an EU directive and is conferred by the 1997 regulations. That protects a substantial investment in, or relevant kind of investment in a database. It's only a 15-year term, but that term starts afresh whenever a new investment is made in the database. And in practice, what that means is that any large commercial database, which is in active use, from a list of vehicle registrations to a list of maps or a commercial mailing list, will enjoy protection for however long it's maintained. And that is a quasi-perpetual right. Passing off and trademarks, which are renewable indefinitely if they're used, may be the reason why Mickey Mouse merchandise may not infringe copyright, but its commercial exploitation could still be potentially restrained in other ways. And finally, as many of you will know, published editions, typesettings, arrangements can be used to evergreen expired rights with the release of special editions, new commentary, and typesetting. Now, very little consideration in all of this appears to have been given to why copyright should be for a longer term. whether that's desirable and whether it actually confers economic or other benefits on the author and in turn society as a whole, and whether those benefits outweigh the costs to copyright users. It's certainly not obvious that a copyright term extension really benefits authors as opposed to publishers. As Ricketson and Ginsberg point out, in most cases, works are exploited by an employer, a commercial publisher, or an assignee who's bought the rights, and they will enjoy the profits long after the author has died. Conversely, where very large investments need to be made to finance the creation of a film or a video game, what term is necessary to recoup that investment? And finally, I raised the question, do all types of work merit the same duration of protection? Does a pizza box design justify the same copyright term as Ulysses? Does my WhatsApp voice note to my partner singing the shipping forecast justify the same copyright term as a recording of Prokofiev's first piano concerto? We've already accepted that the same term does not suit all different types of works. Sound recordings have a different term to literary works. But there is a strong policy against subjecting copyright works to thresholds based on an evaluation of their artistic merits. Of course, booksellers are nothing if not inventive and aren't to be deterred by such minor things as copyright terms. Consider this rather threatening letter sent recently by representatives of the copyright in Prokofiev's ballet scores. Firstly, they point out that as a work of joint authorship, copyright does continue to subsist until 70 years after the death of the last surviving author. And then they politely remind orchestras and musicians that new editions will have been published, and only those new editions will be licensed for future performances. Any other performance, they helpfully point out, will be subject to penalty fees. This is a rather surprising and, in my opinion, unjustified approach. And one is reminded of the submissions given by Attorney General Thurlow in Donaldson and Beckett itself, who reminded their lordships that authors only have what is given by statute or by this honourable company. He then criticised what he saw as a scandalous monopoly of ignorant booksellers who fattened at the expense of other men's ingenuity, grew opulent by oppression. Clearly, much has changed since 1774, but perhaps not all that much. Thank you.
Before we go to Catriona, I have a question for the stations. When I was a boy, I was taught by Blanco White, you could still register things at Stationers' Hall. You didn't have to. And can you still do it? I don't know. I used to advise people sometimes to do it because they could put on whatever they were selling, copyright registered at Stationers' Hall. And of course, you could date the thing. I was told it was £2 and they just put it in the basement somewhere. Whether any of these things are still there and whether you can still pay your £2, I don't know. But we'll find out a bit later on because the master's going to answer.
Well, Sir Robin, it sounds like a good business proposition for the company, if nothing else.
Catriona, she's going to tell us how much this near-perpetual copyright has benefited publishers or not, as the case may be.
Thank you. Well, I'm not quite sure how to follow my esteemed panel members after that great outline, but I will do my best. So hi, I'm Catriona Stevenson. I'm the General Counsel and Deputy CEO of the Publishers Association. And I've been asked to consider our subject matter today from the point of view of publishers in today's environment. And specifically to consider questions such as how significant the copyright term is for publishers and authors, and which older works still have economic significance in the latter years of protection, which works have economic significance in the latter years of protection, and also once copyright has expired, is there much interest from publishers to publish new editions of works? And does the protection they can then enjoy in their own typographical arrangement, for example, provide enough of an incentive and enough protection for that to be worthwhile? I'll also address some of the wider copyright challenges faced today by the book and journal sector, just to give a bit of a broader context to our discussion, and which is perhaps an interesting lens through which to consider the question of copyright term. Of course, because that is only one part of the wider copyright protection which is so important to our industry. Just a few words to start with about the Publishers Association. So we're the member organisation for UK publishing, and we represent over 180 businesses of all sizes and specialisms across consumer, academic and education publishing. And in our membership, we have global and international businesses, we have university presses, learned societies, and small independent publishing houses. And while the biggest part of our membership by market share is the larger publishers, the biggest part of our membership by number is by far and away the long tail of small and independent publishers. My role there is, of course, to look after all the legal work, but notably the intersection of the legal work with our policy and public affairs work, particularly around copyright. And I also have responsibility for our content protection and enforcement, or anti-piracy work. I used to work in the global recorded music industry, and before that I was an IP litigator in private practice. Just another thing I wanted just to touch upon to set the scene is our industry. Publishing is an innovative and growing industry. It's worth £7 billion to the UK economy, or was last year, of which £4 billion is driven by exports. And that equates to over 70,000 UK jobs and supports hundreds of thousands of authors. And of course, the UK is home to some of the world's greatest authors and iconic stories and characters loved around the globe. Books also underpin the wider creative industries, providing source material for film, for TV, theatre and games, among others. And we export more books than any other country. So in doing so, we're exporting UK culture and ideas and research and values with billions of readers and learners around the globe. But the success of our industry, and indeed the wider creative industries, is and has long been underpinned by the UK's gold standard copyright regime, which provides a stable investment environment. It's under this regime that the UK industry has grown to be one of the most successful in the world. So I thought it might be useful just to frame our discussion with a few reminders about copyright. The first is, of its nature, it's a type of intellectual property and therefore a right of property. It's an asset and can be fairly treated as such as part of the wider copyright balance, which I'll come on to. And the second is that unlike its patent and trademark counterparts, it actually does not confer a monopoly right. It's a bundle of rights to do certain acts exclusively, including the right of reproduction. But the right holder must prove copying of their work, I should say, in order to prove that their right has been infringed. So copyright does not prevent innovations which are original, independent creations. And while the copyright term does differ from other types of IP, a like-for-like comparison is perhaps not particularly instructive in that they are protecting different things. The rewards for each are different. And few literary works, for example, will generate as much revenue as a successful patent could, even over a much longer period. So the third thing is that copyright protection, including the length of its term, creates a really important incentive to both create and invest. Authors, creators, illustrators, researchers, these are the lifeblood of our industry, and without them there would be no industry. And the quid pro quo for their creative endeavors must be that there is something sufficient to attract them to write and create in the first place. And in turn, publishers take risks on the commercial success of those creators. Some creators may take time to achieve commercial success, and some may never do so. But I'll come back to that a little bit later. But there's a really important point here, I think, about the stability of right holders to recoup, the ability of right holders to recoup investment and invest in new talent. And finally, the UK's copyright regime needs to preserve a careful balance, and that's between the interests of creators and rights holders on the one hand, and the interests of the public in consuming the output of that creativity on the other. Under our gold standard copyright framework, as I said, our industry has grown to be one of the most successful in the world and an export success story. but a radical change to the balance would likely reduce the incentive to create and invest in the UK and trade away the creative industry's success. And in a world where AI platforms are now consuming copyright works at will without permission, this is as important as it has ever been. So, term. So, as Jaani has already set out, our law in this area is governed by the 1988 Act, albeit with a rich tapestry of amendments, which bring us to the current point in terms of copyright term. And for literary works, this means the duration of the author's life plus 70 years. And other works obviously attract shorter terms of protection. We have the computer-generated works at 50 years and typographical arrangements at 25 years. And copyright is territorial, varies from country to country, which plays a super important role in how licensing works in publishing. But the Berne Convention, which Jaani mentioned, establishes a minimum level of protection for copyright term, being life plus 50. And signatories are then, of course, free to adopt longer durations of copyright protection if they choose to do that. And that is exactly what has happened in the EU and in turn in the UK. So life plus 70 is increasingly the global standard. I have appropriated this map from Wikipedia, and in the orange color, the slightly darker of the two yellows, the orange color is life plus 70. So you can see that covers the majority of North and South America, Europe and Australia, and some other countries. And then you have yellow, which is the Berne minimum of life plus 50. There are some outliers, the blue, turquoise, and black, where they have gone even further, so life plus 75, life plus 80, and life plus 100, which is Mexico, the black one, I think. And at the other end of the spectrum, there are some much shorter ones. So Somalia, there on the east coast of Africa, is life plus 30. But there's a pretty clear direction of travel, it would seem, toward life plus 70. And if we in the UK were to have a shorter term than the global standard, that would be likely to impact upon the incentive to create and invest here, albeit that the wider copyright law considerations, such as the need for balance exceptions and limitations, also comes into play in this regard. It's not just about term. So in terms of the move to beyond life plus 50, Jaani has really touched upon this, but I think I've picked on the one bit that you said you didn't have time to go into. So the two term directives from 2006 and 2011, they have some really interesting wording in the recitals about the justification for going to life plus 70. In the term direction of 2006, which was a codification of the 93 directive and various subsequent amendments, it specifically said here that the minimum term protection laid down by Berne, namely the life of the author and 50 years after his death, was intended to provide protection for the first 2 generations of his descendants, but that the average lifespan in the community has grown longer to the point where this term no longer is sufficient to cover 2 generations. And then the further amendment in the term of protection for sound recordings, on the right of the slide, sound recordings and performances fixed in sound recordings, moving to 70 years. Here they've said performers generally start their careers young, and the term of protection of 50 years does not protect performances for their entire lifetime. So they face an income gap at the end of their lifetime. I just thought that was interesting in terms of thinking about the policy reasons for that increase from 50 to 70. So an example, I picked out here the earliest works of Agatha Christie, in which copyright protection, as I understand it, has expired in the US, but still remains in place in the UK. Just a point of clarification about my slide here. When I say US protection has expired, I'm not saying in every single work of Agatha Christie, just these early works. But the situation is that the UK rights are owned by Agatha Christie Limited, and that is a company that was set up by Agatha Christie herself and which is now chaired by her great-grandson. So this additional 20 years of copyright protection can therefore be seen here as still important and relied upon by the author's dependents. 3rd generation, I think, this one, Jaani. So, just finishing off on this question of why Life plus 70, I mean, it won't come as a surprise that publishers do consider that having that global standard copyright term is appropriate, particularly so when set against the wider backdrop of protection afforded by copyright, which, as we will come to later, is not without its issues in other areas. And the length of copyright, the duration of their lifetime and thereafter is an incentive for creators to create, and the objective is to reward and protect over time their creative endeavor before it becomes part of the public domain for the wider benefit of society. So the fact that the term exceeds their lifetime also means it stands to benefit their heirs. And that actually makes sense given that, firstly, to get a return on a literary work, that's going to come through thousands of individual sales, so it will routinely generate revenue over time, and it needs to be given that time in order to make a fair return. But secondly, that rights will usually revert to the author or their estate if not exploited by the publisher. So there will usually be a reversion in the contract so that the estate itself can then make money from the rights thereafter. And then for publishers, they take risks on authors and invest in them, and the term enables them to recoup that investment. And there are certain genres which may take longer to return commercial remuneration. So, you know, the literature you pick up in the airport, that's probably going to make a large proportion of its profit in the early years of protection. But then there'll be the late blossomer, which will have a second life being made into a movie or translated into another language and find a whole new readership. So the point being that the term length enables successes which might come later in the copyright term. And then there's the point that successful titles in a publisher's catalogue essentially subsidize investment in new authors who may take more years to see success and acclaim. And a successful catalogue enables publishers to invest in works and take risk and publish a diverse collection of authors. And without the copyright protection being what it is, there would likely be less investment in the cultural sector and economy in this regard. One final thought is that a shorter term for orphaned works, or a more comprehensive licensing scheme that's currently available, that could enable publishers to make these works commercially available for public enjoyment rather than being tied up for life plus 70 years. So, I was also asked to consider about which works will still have economic significance in the latter years of protection. There's no formula for this. I mean, if there were, every book would be a success. And there's no list either of titles that are successful. But one factor for a book being successful near the end of its term is the continued investment that's been placed in it during its lifetime by the publisher and other partners. So whether that's film or merchandising, or TV or game or some other exploitation in that regard. Of course, not every publication is still relevant 50 or 70 years after the author's death, but the longer-term quid pro quo for the risk publishers take is that they do get that slightly longer money for the works which are longer lasting. So classic titles, strong classic titles, they tend to have commercial significance in the latter years. They are often reissued and repackaged, and new audiences appealed to. And things like the Penguin Classics and Penguin Vintage series are good examples of this. New translations of foreign works, that can create economic significance in latter years. There's the circumstance I mentioned earlier where copyright expires in another country, and because we operate on a territorial rights-based system, that can mean a greater significance for UK work in later years. And finally, there's the impact of book talk, which I will come to in a moment. Couple of examples. As I noted, new translations of foreign works can create economic significance. The title on the left is Hans Fallada's 1947 novel, Alone in Berlin, which became a Penguin bestseller 60 years after the author's death and publication in German on account of a new English translation. And on the right, this is a current book, but this is a sort of multi-award winning title, which you've probably heard of. And I've just included it here as an example of a work which we anticipate might be expected to have ongoing appeal long into its term of protection. So Book Talk. This is TikTok for books. TikTok is a platform which users can share videos between about 15 seconds and 3 minutes. And I've just put some headlines on this slide, but this is a remarkable situation where novels, old and new, have been going viral thanks to a new wave of social media influencers discussing young adult literary picks on the social media platform. It began as a sort of casual community of readers, and it's just turned into this economic phenomenon. So they share their recommendations and somehow subsequently widen the market for those books. And you know, it's sometimes there's users posting sort of sob-inducing reactions to the ends of books and getting loads of followers. And that led to a book called The Song of Achilles becoming a #1 New York Times bestseller a whole decade after it was first published. So, typographical arrangement protection. Yes, there is clear commercial interest in publishing new editions of public domain works. No author royalty is payable. And protection can also be afforded by cover design and newly commissioned introductions and notes, as opposed to solely relying on the typographical arrangement right. It does offer less protection, of course, because it's the content of the book itself that holds the appeal, and it's very easy to create a new typographical arrangement. But the fact that multiple authors will enter this open market shows that there is interest and there is room for competition in this area. And a good example of this is core school texts and summary notes, which hit the Nielsen charts for weeks every September when the new school term starts. There's also quite a lively current market for illustrated editions and graphic novels of texts, which keeps interest alive. And this is happening more and more now with unexpected titles. So, you could imagine the Tolkien estate authorizing a graphic novel of The Hobbit, or an illustrated Poirot, or, something like that would just, take off. So, to conclude, I was asked to think a little bit about wider copyright challenges. We've talked a lot about copyright term, but the wider copyright balance is, of course, it brings in other factors, and that feeds into the protection that copyright actually affords. So, for example, the need for balanced exceptions and limitations, and having the rights that you need to operate effectively in the marketplace and protect your content. And I've just listed on the slide here a few examples of pertinent copyright issues. So piracy, this is a really obviously one that has been around for a long time, but always morphs into new things. There's widespread unauthorized use of copyright-protected material, things like Sci-Hub, Library Genesis, PDF Drive, Ocean of PDF. That's a huge problem for publishers in the copyright world. Unlawful parallel imports. So I mentioned that we're an industry that works around territorial rights. So quite often you'll have a different publisher in the UK and the US, or in the Indian subcontinent and the UK. And what happens is that publishers will, carefully create editions for different markets, for their different economic and cultural needs. And those editions sometimes get imported unlawfully back into the UK, which is an infringement of copyright. The UK obviously left the EU, and that means that we have a decision to make about what our future exhaustion regime should be. And we have been involved in the last few years in engaging with the Intellectual Property Office consultation about that, particularly because the idea of an international exhaustion regime creates huge issues for our industry. And then finally, artificial intelligence. I was going to focus on this one a little bit more just because it's so topical. Publishers are and have for a long time embraced AI, but are grappling with the unauthorized use of their works to train and operate generative AI models. I want to make it absolutely clear that publishers are not opposed to AI per se. Publishers were early adopters of AI in many cases, and we strongly reject that any false dichotomy that the creative sector is somehow fundamentally at odds with the technology sector when it comes to AI. But the release of large language models, which are trained on vast quantities of content in order to create human-like text, has brought challenges to the fore and really multiplied publishers' and authors' concerns. And the Books 3 dataset, on which many high-profile large language models have been trained, contains hundreds of thousands of books which we know are within the training data. And that poses two significant and related threats to the book and journal sector. The first of those is human creativity. We should support human authorship unequivocally. That's the bedrock of publishing and the wider creative industries. And that creativity is worth around 116 billion this year in the UK alone. If you're an author or consumer publisher, you're now seeing derivative outputs trained on your creative endeavors churned out by LLMs and sold or given away for free alongside your work. And if you're a research or academic publisher, you're seeing the value of your research and expertise hoovered up without permission, attribution, or credit, and inaccuracies inserted into the resulting outputs, which creates issues around research integrity. And then, of course, the intellectual property issue. This probably doesn't need too much introduction or explanation, but we would respectfully say that LLMs infringe copyright at both the input stage in the collection, handling, and storage of content they need to train, and at the output stage where the model generates and makes available content that infringes copyright. And so this is happening on a massive scale, and authors and publishers know that their books have been used to train AI, and they can see copies of their works in the content that is generated. I'm mindful of time, so I think I'm just going to not say too much more on AI, but very happy to pick up with anyone afterwards. I think I'd just finish by saying really that AI regulation is evolving rapidly globally. We're an IP-rich country. It's to the UK's benefit to regulate AI and its use of IP in a way that maintains investment in the creative industries and high-quality data sets, and that we don't trade away our creative industries, in our kind of enthusiasm for bringing AI to the fore. There is the issue around exceptions and limitations in other countries which may be more lax, and AI platforms trying to train themselves there and then operate in the UK. And the EU has introduced an exception in respect of TDM, which it appears will extend to generative AI with a right holder opt-out and a requirement for transparency. But fundamentally, an exception is an appropriate step where you have market failure, and that is not what we have here. We have a market in its infancy, and so the appropriate mechanism for its development is licensing. And a licensing regime exists. It's robust and successful and growing, and many of our publishers license content bilaterally, and our collective licenses are being developed rapidly to meet the needs of the market. So just a few thoughts there. There's obviously ongoing litigation, but we don't have enough time to think about that either. So, have we returned to perpetual copyright? I just wanted to throw a couple of fun examples out there to end on. So the first is in relation to Winnie the Pooh. And the first Winnie the Pooh book went into the public domain on the 1st of January 2022. Cue the creation of a slasher horror film taking full advantage of the copyright in A.A. Milne's classic tale expiring, and reimagining the lovable bear as an axe-wielding villain. No word of a lie. The movie follows Pooh and Piglet, who have become feral and bloodthirsty murderers as they terrorize a group of young university women, and Christopher Robin when he returns to the 100-acre wood. And there's a sequel coming too. And the second, on the right of the slide, relates to a generative AI model released just after the turn of the year. And it can be used to create images of Mickey and Minnie Mouse based on images it's been trained on from a trio of now public domain Disney shorts. So it was trained using a modified version of Stable Diffusion and stills from Steamboat Willie and Plain Crazy and other shorts, and they all entered the public domain on 1st of January this year. So the point being, I think where I was trying to land on this is, If a right holder with the might of Disney cannot and is not armed to challenge either of these developments, then it would firmly suggest that there does come a point where protection ends and that others can begin to freely exploit works in the public domain. And I'll leave it to you whether you rate the output of these endeavors as highly as the original. I think I'm going to stop there, but thank you.
Thank you very much. Our speakers put a huge amount of effort into that, didn't they? Thank you very much indeed. That wasn't written on the... Shall we have a few questions? Right. Yes. Hang on, you're going to get a mic.
Pop quiz for the panel. The following are Nobel Prize economists: George Akerlof, Milton Friedman, Kenneth Arrow, and Ronald Coase. What do they all have in common? They all thought the move from life plus 50 to life plus 70 was a bad idea. When the US did this, there was a Supreme Court case where 17 economists, including 5 who won the Nobel Prize, submitted an amicus brief saying this extends market power with very little offsetting benefit. It's a wonderful world we live in.
Yeah, well, that move to 70, by the way, you gave the reasons the Commission gave, but the real reason was something quite different. It was the drive to create the common market. And there was a case where suddenly they realized that it was 70 years in Germany, the theory being that the fathers had all been killed in the First World War, so you give them extra. So 70 and 50 elsewhere in Europe. So suddenly there was going to be a barrier to interstate trade. And that's why they put it up to 70. You couldn't take the 70 down. You can never take the rights away. You can only add to them. But that's not the reason they gave.
I did read that, but I decided to stick with the recitals because I wasn't sure if it was correct. So thank you for confirming.
Yes, Luke.
Thank you to the panel for a really stimulating debate. I know that Shakespeare has a window in this room, so I wanted to bring up the great playwright. I would like the panel maybe to think about and reflect on the fact that in Shakespeare's time, authors had virtually no rights under the law. I mean, what we talk about in terms of literary property in the 16th and 17th century was never fully recognized by the courts. So it was kind of alluded to, it was there hovering in the ether as this notion, but it was never recognized. And, you know, it might be heretical to say here in the home of the booksellers, but authors were not necessarily in the strongest position at that point. And so I wonder, thinking about, you know, your wonderful presentations, particularly Hector and Jaani, whether thinking again about Donaldson, Beckett, and the Statute of Anne, it might have been the end of literary property as a notion under the common law, but in a way it was also marking the ascension of the author versus the bookseller. That, you know, before the Statute of Anne, the author had this kind of unacknowledged, unrecognized right, but realistically it was the booksellers who held sway. And, you know, in some ways publishers are still very powerful today, but the role of the author has certainly benefited from that statutory recognition, I would argue. And I wonder if you would have anything to comment on that regard.
Start?
You go, yeah.
Interesting question, and there's a whole academic debate, I mean, and not just in law, about the romantic author, or the death of the author, or a whole variety of things about authors. What I think is the most cogent explanation of why the Statute of Anne brought authors into play was to make authors identify themselves. The issue that had arisen very strongly in the 17th century was anonymous pamphleteering. And what was said in the pamphlets was frequently criminal, treasonous, and so on. So part of the idea, I think, is an effort to say to authors, come out into the open because you will get the benefit of these rights. Beyond that, I wouldn't really, I think, wish to comment, except perhaps to something I think Jaani said about the Enlightenment identification of human genius, if you will. I mean, a lot of literary production, or artistic or musical, is not the product of genius, but it all gets copyright. But I think there was this perception that grew in the 18th century that what a person did in that field of production was worthy of some kind of recognition. And the best recognition that's available is money. And the way to enable them to earn money is to provide a right akin to a property right of some sort. I think that's all I want to say, but Jaani may have other comments.
I would only add, I agree wholeheartedly, I would only add that what's quite interesting in looking at the debates around literary property that I've read is you can see how effectively the booksellers appropriated the rhetoric of the romantic idea of the author as deserving of innate property protection, and yet it was the booksellers who had the economic interest in benefiting from that, and who in turn were the ones registering their rights. And one sees reflected in that pre-Statute of Anne, or that system of practice of traditional privileges, a kind of economic rights system, which one is to contrast with the more continental idea of the rights of the author and the way that developed continentally. And actually what's somewhat ironic is that the term extension history that I looked at was mostly driven by the continental sort of approach, that it was important to look after the author and their family, and that was the initial genesis of term extension. And yet ultimately one comes back where one started, with those that control the rights benefiting economically.
Perhaps just a little footnote. The 1842 Act, Sergeant Talfourd's Act, which you mentioned, was driven by considerations about the estates, in particular, as I understand it, of Sir Walter Scott, another Scot, of course, and William Wordsworth, because the perception was that their families would be left in poverty. That was not actually the case, but it was a good, effective bit of rhetoric in the political arena.
I think there are more monuments to Sir Walter Scott than any other person in the United Kingdom, mostly erected out of his estate.
Try Robert Burns.
Okay, one more, then we put it. Oh, let's have one on this side. All right, here we go.
Thank you. Chris King, Royal Philatelic Society, London. As a publisher and author, I'm very comfortable with 70 years of copyright, but as a researcher, it makes life very difficult. For example, the British Library operates a principle of 140 years from publication. So a catalogue produced for an exhibition in 1885 with no author, produced by a committee, with no expectation of copyright, with no purpose other than to record a single event, is still in copyright. This makes my life bloody difficult. I wonder if any of the panel would like to comment.
Well, for my part, I'd see that as closer to the pizza box than Ulysses, and I can only empathise and sympathise. I mean, the problem of orphan works raises a particular practical difficulty, one which a registration system would, in some respects, resolve, but which, for reasons of international copyright history, no longer exists. One might draw an analogy with land title registration, where sometimes you have many overlapping and inconsistent interests in a parcel of land, which through registration can make the transaction cost associated with dealing in that land much lower. And one might suppose there's room for a similar system for these sorts of interests in copyright. The problem is that's now 140 years ago, and tracing the origin is difficult.
Yeah, I do have a thought or two about that. The particular example I'm thinking of is research I'm doing at the moment into the life and work of a couple of Scots lawyers who've both left substantial archives in the National Library of Scotland. And ideally, one wants to quote from these unpublished papers, but the National Library, perfectly correctly, I think, says, no, you can't do that without getting permission of the copyright holders. Now, in one case, the person who deposited the material in the National Library was the daughter of the author in question, and when I first looked at it 20 years ago, she was still alive. But I'm trying to establish whether she is still alive, and if she isn't, who has the right that this particular writer had. The other case is a judge who died a bachelor. He had a brother, also died a bachelor, and there don't seem to be any cousins or any heirs to get hold of. So the strategy has been to just publish and be damned, but with a sort of little note of apology, saying, if the copyright owner should ever emerge, I shall be happy to acknowledge in a further edition of this work, full well knowing that another edition is one of the more unlikely publishing sensations of the future.
Well, the Patent Office has got a scheme where you can go and kind of register orphan works and get permission to use it, and if they ever turn up, then they get some money. It's hardly used. It was bought in about 20 years ago, 15 years ago. It's hardly used at all. If you go and look it up, you'll find about 95% of them are some Irish chap in Belfast, using a lot of photographs of Belfast around the turn of the century. Right, I think we're done. Thank you very much indeed. Master?
Far from being done. I think you've just got started by the sound of things, with all the changes that are going on. Ladies and gentlemen, I think we've had a stunning evening with all sorts of technical stuff about the whole copyright area. First of all, I need to thank Jaani, because I had got my dates wrong. I heard a deep intake of breath when I said something early on. And it was the 10th of April was 1710, the Statute of Anne, but the 22nd of February in 1774 for the Donaldson versus Beckett case, which is why we're here 250 years later in the month of February to think about this whole issue. So thank you, Jaani, for correcting that. Secondly, we had a debate about, I suppose maybe 6 months ago, about music and music copyright and how difficult it is to keep up with all the changes that are going on. And it always seemed, and the conclusion was, technology is always ahead of any kind of legal framework. And I think we're having another echo of that here, where particularly as we get into AI, and maybe before it too, there's always a matter of people trying to get around the laws, and therefore the law needs to change in some shape or form. So all I can think of is that I think the lawyers here have an opportunity to make an awful lot of money, and so I wish you all success. Thank you very much indeed. Finally, talking of money, Sir Robin, you did actually suggest something rather interesting in one of your thoughts about stationers, and how it might be a good idea, even though we don't have to have a registration here for copyright, why don't we do one anyway? Because people might like it at the bottom of their book. So maybe you have just started something, so we'll need a committee to think about this. The clerk is looking at me and going like this. Never mind. Anyway, on your behalf, I'd like to thank Professor Sir Robin Jacob, Professor Hector MacQueen, Jaani Riordan and Catriona Stevenson for giving us such a demanding and interesting evening. Thank you so much.